law matters. Of course it does. Once again, hi, I'm Debbie Moraes, host and moderator of this program. It's been designed to educate, inform, and help you with law matters because, as we say, the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide resources and information that help you decide whether you need or want to contact a lawyer. Perhaps will help you determine that you can handle some issues yourself. If you do need additional outside counsel, hopefully you'll be better prepared. Our goal, of course, is for you to achieve the best possible results. You'll save time, money, and hopefully achieve those better results. Once again, we also want to welcome and thank our guru, our attorney, David Bazar from the Bazar and Associates law firm in East Providence.
Thank you.
So in previous segments, we've talked about landlord and tenant issues. We've covered termination and evictions and foreclosures and various real estate issues. So today, what you as a landlord or as a renter need to know if you're interested in the renting or leasing option to buy. There are many variables, many things to consider. So David, let's tackle it.
Okay.
What do we need to know?
Go ahead.
So when we talk about a rental agreement, you always say, get the scoop and know about what the term is, how much you want to pay, and whether there's dogs and no smoking and whatever else. How does this rent option to buy, how does that change things?
There are many, many different ways to structure that, and given the different circumstances, you have to pick the one that's right for you. So you started out by talking about a lease with an option to buy. That's one form that this can take. So in that type of situation, you enter into a lease just like you enter into any other lease. And then within the lease is the paragraph that talks about the option to buy. And that's where you have to really determine exactly what terms and conditions you're willing to buy the property on, and as the landlord, what conditions you're willing to sell the property under.
Is, for the sake of argument, is rent to own, lease option to buy, are those all interchangeable? And how are they different?
They're actually very different. So the one that we started with, which is the option to buy, you're just renting the property. So every month your payment goes towards the rent, and at a particular contingency point, you might exercise the option to buy. And the option to buy might be you have to notify the landlord, I would like to buy the property for the amount that's already been agreed to, if that's how it's phrased in the option, and follow all the rules and conditions that you laid out. And then you enter into a purchase and sales agreement. The lease to own, as you call it,
rent to own,
or rent to own, could be structured very differently. That could be structured in a purchase and sales agreement. And what you might do is you might enter into a purchase and sales agreement that says, I am going to pay you X number of dollars every month, and it may be that you don't even live in the property. For example, you might enter into a purchase and sales agreement, and this is one that might be designed for a seller that wants to stay in the property, and for whatever reason it's become a little more expensive for them to do that, so they want to collect money from you towards the purchase so that it's affordable for them to stay there. And as they get older, you know, that can sometimes be a little more difficult. And then on the contingencies in the purchase and sales agreement, the property then closes, and under that circumstance, you may end up with a purchase price that you get credit for all of those payments that you made towards that, because you're not living there, it's payments towards the purchase. And we have to talk about all the details you want to put in that when we get to that one. The rent to own, so to speak, now you're living there and you're renting, but in that circumstance, those rental payments may be applied towards the purchase price, but they may not be. And that is all contingent upon a number of different things that you would put in there. And at the end of the day, of course, if the property never closes, you don't get your money back because it's termed rent and it's going towards rent, as opposed to the one I described previously, where you're paying something monthly, but it's towards the purchase price and you're not living there and you're not getting any benefit of a rental payment because you're living there, so therefore you may get all of your money back if it doesn't close.
So many variables. When someone has a property, the landlord, so to speak, they're not sure what they want to do. The person who's just viewing the house, they're not sure what they want to do either. Maybe they are or aren't in love with the house. Maybe they're getting ready. They may need to move. So is there a two-step process that makes sense, that one that covers if they are going to live there for some period of time, it's a year, it's 2 years, and then attach to it a second piece that's at the end of that or concurrent with that, as you call the sales and purchase agreement? What's the best way to deal with that, David?
All right.
With all the unknowns.
Let's take a hypothetical. Make one up. You want me to make it up or you want to
Go
make
right
it up?
ahead, David.
Okay. So in this hypothetical, we have a landlord who owns a piece of property. They don't live in it. It's a rental piece of property for them. And you, as the potential tenant, want to live there, and you may want to buy it at some point in time, but don't have the money or the ability to qualify for a mortgage or whatever at this point in time. So we're going to enter into a lease. And in that lease, it's going to be a typical lease that's going to have all of the terms that a lease would have. The rental period might be a year, 2 years, 3 years, whatever it is. Might have some options to renew the lease. And at the end of that, it will also have this option to purchase. And if you're, as the landlord, interested in selling the property, the right to purchase might have the time frame as a shorter time frame. You know, you have to exercise the option within 6 months prior to the termination of the lease or something like that. It might have the amount that you're willing to sell it for because you know the time frame that it's going to be exercised in, and the mortgage contingency if there is one, and all the other things that typically may be found in the purchase and sales agreement, so that if the tenant exercises the option to purchase, you already know what all the terms that are going into the purchase and sales agreement will be, because simply they exercise it by sending the notice as required, and now you just have to take the terms from the lease and put them into a purchase and sales agreement.
Are there things that happen as you start out as the renter or the person who's leasing? Is your commitment to that landlord different than it would be if you start off knowing this is my time to rent and I think I am going to buy it? So for example, if I think I might own a property, might want to be owning that property, maybe I don't mind participating in the maintenance or the repairs of the house while I'm living there. But if I'm a renter, maybe I'm calling my landlord to change the light bulbs. Hopefully not, I'm kidding. But how do those kinds of variables change?
Okay, so all of those terms in a lease are always negotiable. Who's responsible for maintenance? Who's responsible for snow removal, trash removal, all of those different types of things. So the other thing that I would want if I were the tenant, and I knew this was going to end up being a purchase, would be to get credit for what I'm paying monthly towards the eventual purchase price. So for whatever reason, I can't buy it right now. But in 6 months, I might have a better position. Maybe I'm getting some money in 6 months. Maybe there's something that's coming off my credit that I know will disqualify me now, but I'll then be able to qualify for the mortgage. Whatever the particular facts are, if it's a definite purchase at some point in time, as the tenant, I want to negotiate something that says, here's the amount of money I'm going to buy it for. Here's what I'm willing to pay monthly. I am willing to do all of the maintenance because I know it's going to be my house and I want to maintain it the way I want to maintain it, and I want some credit for what I'm paying towards that purchase price. As the landlord, you may look at it sort of as a rent to buy situation where you're willing to do some of those things and make some of those concessions and take advantage of some of the other advantages you would get with the help of maintenance and that type of thing. But you also want to protect yourself. So what you want to say is, on your side, I absolutely want you to maintain it, but it has to be in a reasonable and workmanlike fashion so that if you don't do it, I have the right to go in and do it. You may say, you need to say what happens if you don't buy it, which is this rent that you're paying me, it's rent. so that if you don't buy it, of course, there's no credit at the purchase point, and you need to have some dates that are hard and fast so that if you really wanted to sell this property, but you've entered into this agreement in order to try to sell it, it's really, for you, another way of selling it, like leasing a car is another way of buying a car. What you want to make sure is that there's a time frame that's tight and certain, and if they don't meet the time within that time frame, that you have the right to then go ahead and put it back on the market and sell it yourself to someone else.
Using your example about the car situation, that dealer is going to tell you, and at the end, it will cost you thus and such if you're going to buy it. If you are in a landlord and tenant situation and someone has agreed on $1,000 a month rent, at the time that they sign, is it worthwhile, or how is it worthwhile for everyone to know at the end of that time what that house should be purchased at, what that sale price should be? Or do you let it go until 2 years, because in 2 years, in one way, the house may be worth more, it may be worth less. How do you plan for that?
Well, if you as the landlord are really not in a rush to sell the house, and you're willing to have a longer term period, and you as the buyer would like to buy it but know that it's going to take a long time to get to that point, like I said in the first example, this is really just another form of a purchase agreement, but it's in the form of a rental agreement because you're not ready to enter into a purchase agreement. So in that one, you would set the price because you know what you're willing to take for it now. You know it's a short-term deal until you get to that period of time. You know what you'd sell it for. The tenant knows what they would pay for it. In one where it's not so hard and fast that this is definitely going to be a purchase and sales agreement, and you're going to give them the right to purchase it, that right may be extended over a 2, 3, 4, 5 year period. You don't know what it's necessarily going to be worth then, and you're not sure what you'd be willing to sell it for then. So there's a number of different ways you can come to an agreement on what the purchase price would be. One way would be that you each could hire your own appraiser, and if the appraisers are very different, or if you can't agree on what the value is between the two appraisers, then the two appraisers might pick a third one, and the parties could agree to whatever that one is. That's one way of doing it. It's a little expensive. Another way of doing it might be to take whatever the value is today that you agree on and put in some kind of tracking, like inflation or something, system that you both might agree to. It's a little bit less reasonable to do it that way. Usually you do that with rents, but if values have gone up by X percent, you could say, well, that's what you'd have to pay. And again, it's not the best way to do it. And so in these type of situations, the best thing to do and the most important thing to do is to try to work something out today that at the end of the lease, whenever the exercise period is going to be, there's no argument as to how you're doing it.
So as in reading about this, as I've understood it, when there's an option, it's a very interesting thing in terms of the landlord and the tenant. The renter, the one who has the lease, has the option to say thanks, but no thanks if you haven't agreed upon price or whatever. But the landlord does not have as an option to not sell. If that tenant wants it, they get it, and they get it at that price. So it's a heads I win, tails you lose. Not technically, but the tenant has the better option. The landlord has none once you enter into that agreement. Is that correct, or what are the variables to that?
So when we are dealing with a lease with an option to buy, the general theory is only the tenant has the right to exercise the option.
Yes.
You can't, as the landlord, say, all right, the option is mine, you're going to buy it. You can't force someone to buy it in a lease. That's not how it works. So you're correct. It's the tenant's option. Therefore, the landlord has to protect him or herself by making sure whatever that exercise price is, or the strike price, or the target price, or whatever you want to call it, the right to purchase is at a figure that you're okay with, that you're satisfied will be fine. And you have to really understand that if it's a set figure, you don't want to stretch that out too long, because in 5 years, that figure may be much less than it would be in 5 years, and you're stuck with it. So you have to protect yourself.
Sounds right. And in terms of disclosures, when someone walks into a house and they're thinking about renting it, the landlord might say, and I'm going to change that carpet and swap out that appliance. But also, that landlord has to be, as we've spoken before, responsible for anything that is a problem. Does that change if someone has entered into a lease option to buy, if they are saying, I'm going to take care of those repairs? And as you pointed out at the top of the segment, suppose the repair is not to the landlord's liking.
Right. So the terms of the lease always control. So you've got to be very careful with what terms you put in the lease and how it's written. So yes, the tenant has the right to buy it at a certain price, but what you also want in that option, if the tenant's been in there and the tenant's been maintaining it, maybe you want to put in language that says in the purchase and sales agreement, it's not necessary to make any repairs or due diligence periods or anything of that nature, because the tenant's been there doing the due diligence and theoretically the repairs all that period of time. So what the tenant needs to know and what the landlord needs to know is the option shouldn't just be the price. It should be all the terms that would go into a purchase and sales agreement, and all of those should have been negotiated out at the very beginning, including whether there's a mortgage contingency, which is always a big issue.
Which is?
So if I need to get a mortgage in order to buy it, I make you an offer to buy your property, it might be subject to my being able to obtain a mortgage for 80% of the purchase value within a certain period of time at the prevailing interest rates, whatever they might be at the time I apply for the mortgage. If I don't get the mortgage, then I can notify you that I didn't get the mortgage and I can cancel the purchase and sales agreement.
Meanwhile, if those are the terms, that landlord can't get the mortgage, that then enables the landlord to say, okay, you can continue staying in that house to that year end or whatever, but also I have the right to show it, make other arrangements to sell it, correct?
As long as you put it in the agreement. And so that's what I'm saying. It has to cover all of those contingencies. So the term of the lease is still a lease. So you have to cover in that lease what happens if you tell the landlord you want to exercise the option to buy and then you can't buy it. Is the lease at an end, or is the term of the lease good through the end of the term of the lease? Usually you would think it would be, but you want to spell all of those things out.
Okay, and along those lines, suppose the landlord had said, no kids, no pets. The lease happens as a lease or rent to own, and somewhere in the course of that lease, or near the end of it, there's a baby on the scene. Not to say that that makes null and void, but that certainly did say that that person didn't wholly comply with the terms that you've listed. That's certainly not a terrible thing, but how about if they just decided that they wanted 2 pit bulls, even though you said no pets? What happens to the terms of the lease then?
The terms of the lease are still enforceable as a lease. The option to purchase usually says that you can exercise the option so long as you are not in violation of any terms of the lease. What would become an interesting case would be, usually that's written in there to say you have to be up to date with your rent, or not out of code with certain things, or as we talked about, if you're responsible for the repairs, for making the repairs. The pet situation, how that might affect the option to purchase, not really 100% sure that it would or should. It's more of whether or not you could evict them for violating the lease. But if they're going to exercise the option to buy and you think it's going to close before that becomes an issue, then you probably would go ahead on a practical basis and sell the property. You don't have to worry about the pet situation that way. But if for whatever reason it doesn't close, you want to make sure that they know that if it doesn't close, they're going to get evicted for violating the term of the lease, for having the violation of the pet or whatever else it might be.
Okay, and in terms of the landlord, when it comes to disclosure, if you are a landlord and you're just renting, I'm not sure that you are bound to tell your tenant as many things as you would if they were inclined to be the rent-to-own situation. What about disclosures? I suspect that this must not be something that is a do-it-yourself kind of situation from what you're describing right now. Sounds like there are a lot of complexities and nuances here. So
none of the different ways of doing this that we talked about are do-it-yourself, because there are too many issues that can get overlooked and too many things that you need to deal with. And which is the best way to do it? We've talked about two, actually, ways of doing this thing. There's another way, too. You could have a lease with the right of first refusal. We didn't talk about that yet, but what that would be is the landlord and the tenant can negotiate a lease with a term on the lease, and it can say that the landlord has the right to sell the property, which the landlord would have without any of these other things in there, at any time. But that you're interested in buying it, but you haven't committed to a price or a term or how that might be. So you might have, as the tenant, the right to say, by negotiating the right of first refusal, if you want to sell it, I want to buy it. So whatever you're able to sell it for, if you get a valid offer, you need to bring to me first, and then I would have a period of time to tell you whether or not I want to exercise my right of first refusal to buy it on the same terms and conditions that the offer is presented to you.
sounds good. And while we're talking about money, many landlords are in a position where they might not want to sell outright because that lump sum may not be something they want to be taxed. Maybe they might even find it advantageous to finance it. Is that something that is a worthwhile or a good solution for some in that position?
Well, as any good lawyer will tell you, that's a question for an accountant.
That's a good point.
But if you sell it and you take back financing, I am not 100% sure that that gets you away from having to pay the capital gains tax.
A good point.
At another date. It's just you agreed to take back some of the money, but you have already sold it for a certain amount of money. You may still be liable for the capital gain. I'm not sure. An installment purchase, however, might be a little bit different because they might be paying you like the lease would do. That's really sort of an installment purchase. But since you haven't transferred ownership until a later date, you might not have to pay anything on that until that later date. So, as a good lawyer, I'm going to tell you, you need to speak to your accountant about that.
And the tenant who has trouble, perhaps, as you say, for whatever their financial situation may be, maybe they don't have the down payment, maybe they're waiting to sell their own house or whatever. So for them, these options, as they are, might give them some flexibility that they might not ordinarily have, especially if they're not sure if they're on the fence about whether or not they fell in love with the house in which they're living in.
Sure, it gives them a lot of flexibility. And as I said to you at the beginning, the other side of the story is the landlord who lives there and wants to sell it, but can't afford to stay there right now, but might need some flexibility of some money to be able to stay there and then eventually sell it to you, which is why there are all of these different ways of structuring a real estate transaction that can take into account all of the needs of both the seller and the buyer.
Inspections. If you're renting, the landlord doesn't need one, but if you are doing rent or lease to buy, I assume that they do need to go through all of those issues, correct? Or no?
You know, it depends on the situation, but usually if I were the landlord, you know, you want to have this as easy a transaction as you can and take out as many contingencies as you can. As the tenant, I want to protect myself even though I've been there. So although I've lived there and I know a little bit about the property I'm buying, I might still want to have in my option to buy the right to have inspections done, to bring in somebody who knows more about property than I do to look at things and tell me to make sure I didn't miss anything, and some expert who has the ability to tell me, well, this is a problem, that's a problem, so that I can still talk to you about it and still have a way out if it's a problem that I wouldn't have known about.
And another financial issue I've read about an option fee. So even if a tenant is interested in one of those options, they may not have a down payment, but is that another term for them being willing to give more money than just the rent in exchange for whatever this option may be?
Well, as the landlord, if I'm looking to sell the property and you're asking me to hold the property off the market so you can live there, many times that's got some value. And you might say, I'm willing to give you an option, but here's what I want you to pay me for it. So there could be a non-refundable amount of money that the tenant would pay to the landlord for the option. And it may be, because you can negotiate a lot of these things, that that's a number that would also be applied to the purchase price if you buy it. So non-refundable if you don't, applied to the purchase price if you do, but many times these options come with a cost.
So we've talked about various structures. I imagine that it's also true that there are other variables that have to be taken into account, which are state to state, correct?
Sure.
So, and that may be with disclosure or terms as well?
There's all sorts of things. You know, in Massachusetts, there's septic laws that have to be covered. There's lead paint laws that have to be covered.
Radon?
Yeah, all of those things. So all of those terms and conditions still, even though it's just an option, like I said, you want to put all of the information would be in a purchase and sales agreement in that option. So all those things are covered.
You know, we talk about giving people resources to help them be better equipped to either do it themselves or to work with a lawyer. And from what I've seen, there's a NOLO, NOLO.com, which is certainly a good resource, as even are some wikis, which are small Wikipedia entries that give insights into how to, when to, and where to. I would think, based on what we've discussed here, that a quick read of some of those things would help someone put together a checklist by the time before they came to see a lawyer, so that at least they'd have some better questions to ask that would help you better draft that piece of paper or that document.
If you're better prepared, so will your lawyer, and therefore you may have a better result.
And apparently they do have listings, even on NOLO, about some of the differences from state to state. Obviously, we're on the East Coast. California has some very stringent issues to deal with. So is it better to start out with a final destination, or do you just go open-ended when you try to do these landlord and tenant situations? Is it worthwhile to just see where it goes after 1 year?
I think it's like any other transaction. The more information you have at the beginning, the better you're able to express what your goal is and what it is you want to accomplish, the better off both sides will be at the end of the day when they try to get their agreement drafted.
It's been very helpful. We've certainly covered so many terms. We hope that this has been helpful to you. We hope that you will continue to stay tuned to the Law Matters, because as we always say, it matters to you.